All right, welcome everyone. Thank you for joining our program today, Green Claims, Red Flags, Managing Securities, Antitrust, and Consumer Law Risks and Sustainability Initiatives. To my right, I have John Solorzano. John is a partner at V&E. His practice focuses on advising public and private companies and their boards of directors and executive teams on risks and opportunities related to ESG, corporate governance, sustainability considerations, shareholder activism, risk management, securities law, and M&A. To John's right, we have Jason Powers. Jason is the co-head of our firm's antitrust practice group. He handles complex business controversies, including competition law matters, consumer class actions, and multi-district litigation, and disputes over joint ventures and major investments. We have Mei Lin joining us remotely. Mei Lin heads up our European competition practice, having just recently opened our Brussels office. She regularly advises clients on the antitrust aspects of their sustainability initiatives and on industry collaborations on sustainability issues. And again, my name is Reese Poncia. I am a senior associate in our DC office within the Complex Commercial Litigation Group. My practice focuses on both civil and criminal antitrust litigation, representing clients in class actions and multi-district litigation as well. I also do antitrust and consumer protection counseling on the full gamut of both federal and state consumer protection laws for things like claim substantiation, labeling, advertising, social media, really anything you can think of in that space. With that, I will just run us through a brief agenda for today's presentation. So today we'll be diving into green claims and some of the issues to spot when making green claims or getting involved in sustainability collaborations or initiatives. So we plan to lay out the groundwork for some guardrails when making claims or getting involved in these types of industry collaborations. We'll start today by going over the multidimensional impact of ESG. We will then turn to some antitrust considerations, both in the US as well as globally, specifically in the EU and UK. And then we will wrap up with a consumer protection rundown. So today's learning objectives, just to sort of level set everyone here, it's important to keep in mind that ESG initiatives, green initiatives, and campaigns really implicate multiple areas of compliance and enforcement, whether it's the FTC advertising rules, the Sherman Antitrust Act, or other types of regulatory and disclosure obligations. So it's important to keep in mind these various areas of risk when putting together these types of green campaigns. So we'll touch a bit on both the fiscal and reputational harm to keep in mind when evaluating risks of making green claims. We'll do a deep dive on collective action efforts in the ESG space and antitrust guardrails to keep in mind. We'll also discuss the FTC Green Guides and the general regulatory and litigation landscape as enforcement avenues. And finally, we plan to present strategies for issue spotting and walking back any claims as needed. So with that, I will now turn it over to John to talk about why we make green claims in the first place.
Thanks, Reese. So I think the bulk of our conversation is going to be about the risks associated with a lot of claims and how to navigate those, because it's a multifaceted risk landscape. But I want to back up a little bit and sort of talk a little bit about why we're even making these claims in the first place, because particularly for in-house counsel, and full disclosure, prior to me joining V&E, I was in-house counsel for 10 years. I recognize that the demands from your business are going to be pressuring the company to make these types of claims. There are very valid reasons to make these claims, and I don't want to make this conversation solely about the risks, because there's a lot of upside. And so that's really what's driving some of the behavior, and then that informs how we think about the risk analysis, whether that's antitrust or FTC type of risks. First and foremost, particularly if you're in a consumer-facing industry, my background, I was in consumer packaged goods before coming back into private practice. There's a lot of demand from consumers for sustainability position products, whether that's in packaged goods or foods or materials that are in and around your body, for instance. There's a lot of reason to make these claims on things being organic or free from certain chemicals, or the packaging is more recyclable or what have you. So that is driving a lot of value. And so on the top of this slide, you'll actually see this is some data from NYU Stern that shows sustainably positioned products have a CAGR, compounded annual growth rate, of 2.3 times standard products. That is a real business driver for a lot of companies, and so I don't want to lose sight of that fact. That is a very strong reason to make these types of claims. However, those claims need to be made smartly. So, I've spoken a little bit about how the consumer cares deeply about this. Interestingly, I would say the investor cared deeply about this up until very recently, and it's a very complicated landscape we're in now. But starting in the 20-teens to about kind of early 2020s, the large institutional investors, led by this gentleman on the screen, Larry Fink, who's the CEO of BlackRock, were openly declaring that companies needed to care deeply about climate change, set net zero targets, do all of these things because, if you're not fully plugged into the IR slash, shareholder relations type of world, your BlackRock probably owns 10% of every public company in America, and then Vanguard, State Street, all of the others combined have a massive market power if you're a publicly traded company. They were openly declaring things like climate risk is investment risk. Companies were sort of feeling under a lot of pressure to set net zero targets, to develop net zero transition plans. And that has kind of hit a wall. And, talking a little bit about the anti-ESG moment that we're in now is probably a conversation for another day. But suffice it to say that pendulum has swung probably back to investors. I wouldn't say that they don't care, but they're not being as vocal about caring in a way that they were a couple of years ago. And there was certainly a bandwagon effect where companies felt like they needed to do these things or else they were going to be left behind or they were going to be seen out of step with their peers. So that's really what drove a lot of these type of commitments. And Reese will speak a little bit about this in a second. You've got the consumer-facing claims, which have a well-worn kind of green guides, green claims type framework around them. But those types of claims now are starting to affect ESG-focused claims, so corporate commitments that you would find in your sustainability report or your corporate social responsibility report. Those are now subsumed under this kind of risk category, and I just want to be very mindful that we're going to be talking a little bit about both, but ESG risks have become much more prevalent. So just speaking quickly on these three topics here, this is a multidimensional risk landscape that we're in. The regulatory regimes have clearly leaned into these types of claims, particularly under the Biden administration. The SEC was focused. They even set up an ESG task force. Within blue states domestically, there's still a lot of focus on regulations around claims pertaining to green or eco-friendly. In Europe, and Maylin will speak more specifically about this, that is clearly the trend. There's a little bit of complexity with that, but it's clearly the trend. And then domestically, because we're a very litigious society in the United States, the plaintiff's bar has also leaned in heavily. So I think the perception that you can make these kind of no regrets types of commitments has gone out the window, because if you make these commitments without a plausible plan, and we'll talk about that in and of itself could raise some risks. There's a number of other things that add to the complexity of the landscape. If you were to be investigated or if you were forced to pull down claims because of a government investigation or whatnot, that could have serious ramifications on your business. First off, it's a headache, but also it actually forces you to curb some of the claims that you've been making, which could have a deleterious effect on the business's ability to sell product, for instance. And then I will also just mention reputational erosion. That is, I think, kind of an underlying theme of all of what we're going to talk about, particularly if you're in certain industries. Developing a reputation is very hard to do. Losing it is very easy to do. And so companies need to be mindful that they've developed this trust with their customer base over sometimes decades, and it can be lost quickly if they're seen as being hypocritical or inaccurate. And that is a real tension for companies to be mindful of. Next slide, please. Again, going to the capital markets consequences, I mentioned a little bit about kind of the large institutional investors and how they're sort of leaning out. But, it's complicated because domestically they might be leaning out. I would say in Europe in particular, they're still very much leaning in. And so there's a bifurcation between your shareholder base in the United States and, for instance, some of the Nordic investors, they might have a very different perspective on things. And so they are expecting companies to behave in certain ways, and they were using the leverage that they also have as being large shareholders to demand these things of your companies. Maylin will talk about some of the global antitrust considerations, so I won't get into that. The last thing I'll just kind of preview that we'll talk about is fundamentally these are board-level questions. You need to be asking yourself, is making the claim worth the risk? And it could be, and I'm not trying to suggest that it shouldn't be, but you need to understand your own business, you need to understand your own stakeholders, you need to understand the risk environment that you live in. And then beyond that, you also need to be mindful of making sure the governance processes are in place, because one of the challenges, and I saw this when I was in-house, is you have well-meaning marketing folks, well-meaning IR folks who've been saying some of these things for years, and legal wasn't involved in some of the decisions. And some of those statements live in your CSR reports, they live on your website, or they live in social media campaigns. Sometimes they might even end up in some of your SEC filed documents. Those are potentially very risky now that the regulators and the plaintiffs' bar are focusing in on these. So I'll stop there.
Well, I think the last few years, as John mentions, antitrust has become a significant source of exposure for companies who are very public-facing on their ESG concerns and commitments. And you might ask, why is that? Well, I think you think of it this way: antitrust is always a tool that one can use to question market outcomes. Right? If you think the market does not reflect what market actors would be doing if they're able to express themselves, make free choices, have a completely open market, then you might ask, what is constraining the market? What is it that's causing everyone to behave in some way that you think is some sort of unnatural behavior? Could it be that there are dominant actors who have agreed somehow to restrain open markets? And during the Obama and Biden administrations particularly, there's this idea that started to percolate on the right about, especially among those who were committed to this idea that so-called wokeness had taken over corporate culture, and the idea was that somehow the political or cultural left had caused businesses to coordinate their activities to behave in some kind of quote unquote politically correct fashion, and anytime you have businesses that are coordinating conduct in ways that distort markets, you could consider antitrust as a tool to either combat that coordination or combat the effects of the coordination. So this idea really catches fire when, in 2022, when the House flips red during the Biden midterm election, and you get Republicans running the House Judiciary Committee. And that committee, of course, has always had a large role overseeing antitrust enforcement by the Justice Department. So you get a couple of members on that committee who are very interested in having this sort of anti-wokeness as part of their platform. And picking up on this coordination idea, they start launching investigations claiming that powerful trade groups are either preventing free expression by the online right, or controlling the media, or targeting disfavored industries, and thereby violating antitrust law. And they issue several reports about these investigations, and before long, others are picking up on the idea as well. So you start to see investigations and lawsuits of various kinds. I'm sure different views on whether or not these reports are about politics or about competition, but even if you're skeptical of the merits of these claims, there were some ways in which industry had opened itself up to some scrutiny on these issues. And the primary risk is in ESG initiatives that involve collaboration between companies who would otherwise be competing. Part of the reason has to do with the manner in which these collaborations get organized. So suppose you are an advocate on some environmental or political issue. You're trying to affect change, and you want to encourage this broad consensus that your issue is a very important one. You might form organizations and go to businesses and make the case that it's in their interest to take steps that will advance your cause, right? Or associate themselves in the public eye with whatever your laudable goals are, and you want to convince businesses and the public that you are effective in accomplishing those goals. So you get these various advocacy groups, they're competing for attention, they're competing for contributions, and they're all saying things like, we're going to cause, a net reduction in some pollutant, or we're going to increase the hiring of a certain group of people, or we're going to reduce greenhouse gases, or whatever it might be. And how they're going to get there may not be clear, right? There may not be a very specific mechanism by which they're going to accomplish their goals, but they tout the idea that getting everyone in a room, getting the industry together in a room is going to be a difference maker of some kind. And this creates a really special risk that didn't exist before, because when these advocacy groups approach companies and say, get on board with us, they're not going to the parts of companies that are usually sensitive about antitrust risk, right? They're approaching community engagement teams. They're approaching PR teams. They're approaching government relations teams, people who aren't trained since the first day they got on the job to be cautious about how you talk to competitors. And all these organizations, they've got very laudatory goals, so they don't trigger that same kind of just instinctive concern. If someone in a company walked around the office and said, I want to go meet with my competitors so we can jointly find a way to get rid of our low price competition, someone would see a red flag immediately, right? Someone would call the in-house counsel and say, what do we do about this? Because that's not something we're supposed to be doing. But if someone says, look, I want to go to a meeting so I can learn about how to save the whales, that just sounds like something nice people do, right? And so it might not even come to the in-house lawyer's attention, but it needs to come to their attention because we see claims springing out of these well-meaning advocacy efforts. So an advocacy group says, we're really worried about online hate speech, and we want to give advertisers tools so they can know where their ads are going. That group gets slapped with a House Judiciary investigation and later a lawsuit alleging what you've really done is you've encouraged advertisers to share information about what ads they're buying, and you're trying to organize a boycott of Twitter, and group boycotts sometimes violate Section 1 of the Sherman Act. Or you've got an advocacy group that says we want to encourage a transition to a low carbon future, right? And their members get slapped with a lawsuit by 15 Republican state attorneys general arguing that competitors are now conspiring to suppress the production of coal. Or groups that encourage the greater use of recyclable plastic and recyclable packaging, getting investigated by the Florida Attorney General and others, arguing that what they're really doing is they are conspiring to exclude low-cost providers from the market or artificially increase demand for some favored environmental alternative. And all these claims really come down to the idea that the market's being distorted by powerful interests for some political or social or cultural goal, and we wouldn't have that market domination, we wouldn't have that market distortion if everyone would just focus on the core American values, bigger, better, faster, more, right? Now, I'll tell you that having been a part of some of these investigations and lawsuits, the economics of these claims are often very suspect. The idea that some climate advocacy organization talks about an issue and then on down the line you can actually see people's power bills rising, or you can see some real change in the economics of the underlying markets is really questionable. But the groups are not helping themselves because they love to say they're making a difference. They love to send out press releases saying they're doing a great job. And the folks who write annual reports for companies love the idea of saying, we care about the climate, we joined a group that's working to accomplish all these goals, our industry is working together to make a real difference, transitioning away from bad stuff and transitioning to good stuff, often forgetting that the people who are the bad stuff sometimes have friends with enforcement power. Right, and they may see that idea of we're working together to move away from that as essentially a Section 1 claim. So what should companies be doing to protect themselves? You want to look at the advocacy organizations the same way that you would look at competitor collaborations generally. First, what's the stated purpose of this group? What does it say it wants to accomplish? Competitors can often collaborate to create new competitive options. That's good. If two competitors work together and they make investments that help scale production of some environmentally friendly input, that's a lot easier to defend than two competitors getting together and saying, let's agree to stop using some disfavored commodity or some disfavored supplier. Or if the purpose of the organization is to lobby for new laws or new regulations or new environmental rules, that would be constitutionally protected activity. The Noer-Pennington Doctrine would exempt that from antitrust law altogether. So the purpose and the plan of the group is really important to understanding how much risk does a collaboration present. Second question would be, what kind of commitment are you making when you say you're going to join some collaborative effort? If you join, are you agreeing that you won't produce more than X tons of emissions? Are you promising that you're not going to buy from some seller that the group identifies as being a bad actor? Or is the company always maintaining control over what it buys, what it sells, what its prices are, and so forth? If you've got some collaborative organization that says we're going to keep you informed about an important issue, or we're going to speak out on some issue, that reads very differently than an organization that says we all commit to behave the same way in the marketplace. That's a very different kind of environment. And then third, how are the organization's meetings and communications handled? Do we have good hygiene for these things, as we say? When sophisticated companies join trade associations, they expect that when they send their employees to those meetings, to the trade association groups, there's going to be someone who's planning the agenda, there's going to be someone who's keeping the discussion on topic, and that participants in the organization will all know the rules of the road. They'll know when they're supposed to talk about certain kinds of things and what kinds of things they can't discuss. And if your company is participating in an ESG organization of some kind, and competitors are going to be in the same room together, then the approach to those meetings need to be the same as if you were sending the salespeople to the trade conference, right? The people who are going to attend need to be sensitized to the risks of how you talk with a competitor. And the organization itself, of course, this is not just on the companies who participate, but the organization itself needs to give attention to whether it's set things up in ways that are robust to scrutiny rather than things that foster suspicion. And similar kinds of attention need to be paid when you are joining groups that encourage various kinds of reporting on social issues or climate issues. So there's lots of different organizations that want companies to say, where are you buying your inputs? Do you know your suppliers? Are you depleting scarce natural resources? Do you know who's working in your factories in lesser developed countries? Are you buying products that pollute? Getting information like that and making it accessible to consumers can impact buying decisions. As John was pointing out, it can be an impetus to change. The question the antitrust lawyer needs to worry about is, does our participation in the organization mean that we're handing out information that creates antitrust risk? And that would be stuff like, is the data that we send to the advocacy group the kind of data that our competitors would like to know about? Does it give you a window into our production plans? Is it data that would impact anyone's pricing? Is it current information about our prices and our production going to our direct competitor? Or is older information being kind of bundled up and assembled and blended and aggregated in a way that nobody could really make a pricing decision today based on it? Those are the kinds of questions you would ask if someone said, should we report data to a price reporting service or to a publication like Platts? You would assess the risk that participating in the information exchange will facilitate price fixing. You're going to have to ask the same questions about ESG collaborations if they impact your supply chain or they impact what you sell. So, these are the kinds of considerations that are really important to managing your U.S. enforcement risk, but the perspective is a little bit different on the other side of the Atlantic. So we should turn to that topic next. Mei Lin, can you talk to us about the way European enforcers think about these issues?
Sure. Thank you. We can just go straight to the next slide. And it's not going to be a surprise to anyone that in the EU, we take a slightly different view to this and we come at it from a different lens. So in Europe, our largest sort of antitrust regulator, the European Commission, has sort of actively come out to sort of support sustainability cooperations and saying that genuine sort of sustainability collaborations between market participants can actually sort of contribute to real sustainability goals and bring out sort of sustainability outcomes in a more efficient, more effective way. I mean, they've gone so far as to say, competition law enforcement actually has a role to play in contributing to sustainable development. They've also acknowledged that, cooperation agreements may actually sort of cure or address, market failures that are not fully addressed by, legislation or public policy. And so there's a real sense from, the European Commission side that, and that's, our key regulator, as I said, of not wanting to stand in the way of sustainable cooperations where there's sort of real value to them. And so to that end, they sort of issued horizontal cooperation guidelines a few years ago. And the purpose of this is really to give companies comfort on the various types of horizontal collaborations. So collaborations between, competitors or actual or potential competitors on the market and their behaviors. And one of the chapters actually specifically addressed sustainability. And sort of folded in there, is, a few sort of great nuggets for us. One thing is the European Commission acknowledges that, sustainable cooperations can be beneficial to the economy, to consumer welfare. They also say that they take a broader concept on sustainability. So this is not just, looking at this from a strictly environmental lens, but also, things that benefit society in general, or, some economic concerns, such as ensuring that, laborers have a living wage, or, protecting human rights issues can also fall in the bucket of sustainability. And the other thing that these guidelines actually provide, in terms of comfort, is on standardization agreements that relate to sustainability. So the European Commission has sort of come out to imagine situations where companies are saying, okay, we have individual efforts, we have standards on how we sort of buy our products within the supply chain. But look, getting together and doing this is much more efficient. It's going to bring about change in a better way, in a faster way than would have been if we sort of did this individually. And so we're going to come together and set some standards on how we buy things, how we procure our inputs for the products that we make. And so folded in the sustainability guidelines that the Commission's come out with, is actually a soft safe harbor of sorts, where they say if you meet sort of 6 conditions, and a lot of this is covered by what Jason was saying, sort of things like protecting, the information exchange point, making sure that you're not using your meetings as a way to actually collude or things like that, ensuring that the standardization process itself is open, transparent, allowing market participants to actively contribute. And so they give out these sort of points that you have to meet, and provided that you meet all 6 of them, the Commission saying that these standardization agreements on sustainability should be okay from a competition law perspective, and that we're fairly comfortable that this should be fine, and not going to affect competition in a negative way. So this is it's quite a novel approach. I mean, they've also said, look, if there's any sort of residual concern from market players that don't know how they're going to actually comply, they're actually welcoming engagement. Companies can come forward, discuss with the Commission, and seek what's known as sort of comfort letters. And this is sort of an informal guidance approach. And the Commission's actually willing to invest time in hearing from companies and giving them guidance on their sustainability projects. So we do come in at it at a completely different lens. At the same time, I mean, this is not sort of, immunity from antitrust enforcement whatsoever. The same concerns that Jason outlined earlier on, price fixing or information exchange, that still stands. You can imagine, an agreement where people say, okay, we're going to invest in sustainability, we're going to save the whales, as his example was, that's going to cost us a lot of money. At the same time, let's all agree that, we're going to pass down these costs to our customers. That sort of it's coloring outside the lines, and that's going to be, the subject of antitrust enforcement. The last sort of slide that I have here, I just really wanted to do a quick compare and contrast with other jurisdictions. So in the UK, it's fairly similar to the approach in the EU. Of course, the UK is out of the EU now, and so has its own set of rules. They've issued their own sustainability guidelines. One thing that's quite interesting is they've taken a narrow approach to sustainability, and they say that this is only sort of for environmental benefits. We're not specifically recognizing, for example, living incomes or human rights issues in that bucket. But similar to the European Commission, they're welcoming sort of engagement. So they have what's called an open door policy, where they're saying to companies, please come forward. If you're unsure about something, come and have a chat with us. We can issue sort of guidance or comfort letters. It's not a formal exemption process, but it should give market players a level of comfort. And other competition authorities are also sort of issuing similar guidelines around the world. I just want to spend maybe the last sort of minute sort of talking about Brazil and a different approach that they're taking. So in Brazil, sort of fairly recently, we had the soy moratorium case. This is a situation where purchasers of soy have gotten together to say, we are going to agree not to buy soy from deforested land. Again, sounds like a laudable endeavor. The issue is that there was sort of, a number of complaints coming up. And then, so the competition authority opened an antitrust investigation. And they're saying that, well, it's not for companies to get together to decide on what the law should be doing. There is law in this area. There is no reason for sort of collective action on this. And so they're opening this investigation, or they've opened this investigation from the lens of, this is a collective boycott situation, and really more looking at this in line of a typical sort of classic cartel situation, rather than, I think, what I've outlined as the approach in the EU, which is, competition law shouldn't stand in the way of genuinely good things for the environment. I'll hand over now to Reese.
Thanks, Mei-Lin. So now we will turn to some consumer protection considerations, which we will focus on for the rest of today's presentation. So to kick things off, I just want to touch briefly on the FTC's green guides and some other basic consumer protection and truth in advertising principles. So the FTC's green guides are the FTC's official interpretations of how truth in advertising principles apply to environmental marketing claims specifically. Currently, they address things like recyclable, free of, compostable, but they are way past due for an update. They have not been updated to address more commonly known phrases today, such as carbon neutral or net zero, things that really came to the forefront since their last revision in 2012. So just a brief status update. We are awaiting an update on these. The FTC initiated a public comment process in 2022. A comprehensive revision is widely expected, but it's still sort of in this limbo state. So we will see when we get that update. It's important to note that these green guides are technically administrative guidance. They're not actually law, but the FTC looks to them as the golden standard, and state AGs and other sorts of enforcers as well look to these as the golden standard and sort of the bare minimum when making environmental marketing claims. It's worth also noting that there has been increasing focus as of late in bringing actions against green claims that not only have explicit textual claims, but also use things like green imagery, forest imagery, things that could convey an understanding of an environmental marketing claim without actually saying it. So just to touch on a few truth in advertising guidelines to keep in mind when making green claims. First, you must ensure that there is a reasonable basis to make a claim before it is published. Key is before it's published. Under Section 5 of the FTC Act, you have to be able to substantiate all express and implied, so all reasonable interpretations of a claim. Under the Green Guide specifically, you must be able to substantiate all reasonable consumer takeaways and ensure that each claim is truthful and not misleading. You also have to ensure that you have competent and reliable scientific evidence. That is the base standard here. And basically what that means is having studies, surveys, analyses, preferably third party, that can back up the claims that you are saying. And then finally, you have to be careful about making unqualified broad claims, things like green or other phrases that might be difficult to substantiate. So using things and qualifiers, which I'll talk about in a little bit, to make your claims less misleading is something to keep in mind. Just a few more guidelines to touch on net impression and disclosures. So regulators, as I mentioned, will evaluate all reasonable interpretations of the claim, but they will also evaluate the entirety of the ad or the net impression. So again, not just the words that you put in an advertisement or in a green campaign, but the images, the colors, the layout, the overall impression. It's important to make sure that every way that you look at the ad is truthful and accurate. Specifically, green packaging or forest and leaf images, like I mentioned, they can create this implied environmental claim without explicit text. For example, in 2021, just as one real-world example, one of the world's largest retail corporations paid a $3 million settlement to settle FTC allegations that textiles marketed as bamboo fiber were actually chemically processed. The FTC alleged that the packaging imagery and language combined to create a misleading net impression. So again, there's enforcement in this space when looking at the overall net impression of an advertisement. Next, I briefly mentioned this, but any qualifications or disclosures for green claims, which can often help manage risk, must be clear and conspicuous. And so what does clear and conspicuous mean? This is a phrase the FTC loves to use all the time. Basically, what it means is it can't be hidden. It can't be buried within text. Maybe it's by using small font or a faint color. It has to be legible and visible to the consumer, preferably not buried behind a hyperlink where you have to click on it to understand what the qualifying language is for the claim. The FTC likes to say it has to be hard to miss. And then disclosures and qualifications, like I mentioned, can just help manage risk. Adding in caveats to explicit claims can help avoid making vague or potentially misleading claims. So just as one example here, instead of saying 100% recyclable, if that's not 100% truthful and accurate in your opinion, you could add in qualifiers that specify things like made with 40% post-consumer recycled content. So next we'll chat a bit about greenwashing and future washing. These may be terms that you are familiar with already. I'm sure you've heard greenwashing, perhaps not future washing. But basically greenwashing is the practice of making misleading, deceptive, or exaggerated, or even false green or ESG claims. For example, by overstating how sustainable a product is, or a company is, or a future investment strategy or strategic plan is. An example of greenwashing recently in the news relates to a proposed class action claiming a baby product company falsely marketed its cleaning products as natural, plant-based, and safe, when in fact they contain synthetic or potentially harmful ingredients. So plaintiffs allege that consumers were misled, that they overpaid for these products. This lawsuit was filed in California federal court and not only seeks damages, but changes to the company's product labeling. So touching a bit on what John mentioned earlier, is it's not just financial risk, it's also operational risk. Having to redo and pull packaging and start that process over is a real business impact. Finally, future washing is when someone makes an ambitious forward-looking commitment such as net zero by 2060 or carbon neutral by 2060 without having that competent and reliable scientific evidence I mentioned to back up those claims. So these types of claims can be viewed as creating an impression of environmental responsibility, but pushing off performance to a later date. And both greenwashing and future washing claims can create significant litigation exposure. Just a few things to keep in mind when making claims in the ESG context. So ESG goals and sustainability reports, as John mentioned, are now viewed as marketing claims, so they fall under this scope of compliance. So any goals or findings that are being published by your company should comply with all these same truth in advertising principles I've mentioned. It's important to keep in mind that goals to be net zero or carbon neutral by a date down the line may not be viewed as puffery or basically an actionable exaggeration. They actually require these plans and studies to back up those claims. And one final note that is probably not surprising to anyone, AI tools are making enforcers and regulators' jobs a lot easier these days to find green claims to enforce. The FTC are known to use their web scraping tools, their data mining tools, other advanced AI-powered tools to search for false advertising, deceptive claims, and fraud. So the risk of enforcement here is high as of late. So finally, just to touch on greenwashing or puffery, when do you know when a claim comes from, puffery to an actionable greenwashing claim? And again, puffery is something that's typically inactionable to a reasonable consumer. They might understand that it's not an accurate claim. So looking at this scale here, which I like to call the sliding scale of risk, of course, some companies are much more comfortable at certain ends of this scale than others are. Really comes down to the ultimate business decision for you. But just to illustrate a bit here, what could sort of start out as puffery and lean more towards an actionable greenwashing claim. So starting at the lower end of the scale here, we have United's Eco Skies program. In 2023, plaintiffs filed suit against United Airlines alleging that their marketing of their Eco Skies program as 100% green was false and misleading. Now, 100% green, I think to a reasonable consumer when you're looking at an airline, it's fairly sure that that's going to be viewed as puffery. I don't think, most reasonable consumers wouldn't look at an airline and think that. So it's probably a phrase that you should raise your eyebrows at, and this case was actually ultimately dismissed, but again, towards the lower end of risk. Next, we have 100% recyclable claims. a few years ago, a few food and beverage companies were targeted by the European Consumer Organization, or the BEUC, for claims that their plastic bottles are 100% recyclable or 100% recycled. The BEUC claims that it's actually not possible to make that claim quite yet. And in response to this, some of the companies agreed to change their labeling on their products to comply and have more specific disclosures and qualifications. So again, that product impact is at risk. Next, we have Delta Airlines. John will speak to this a bit more, but just to briefly touch on this, they had a claim as, quote, the world's first carbon neutral airline. They're currently facing a class action lawsuit regarding its carbon neutrality claims. They actually included on their in-flight napkins, again, a marketing claim anywhere is a marketing claim, that you can travel confidently knowing that we will offset carbon emitted on your Delta flight. So again, this falls into that category of potential future washing that companies must just be aware of and be careful making. Next, we have Cleaner Solutions. So 2 very large retailers reached a $3 million settlement with the FTC a few years ago for environmental benefit claims regarding fibers derived in whole or in part from bamboo. These producers marketed their products with a Cleaner Solutions label to indicate that they were free of harmful chemicals, when in fact they were using chemicals and non-synthetic materials, or synthetic materials. So these were actually found to contain synthetic chemicals. So again, this is sort of on the higher end of the risk scale. If you are in fact not using, products that are produced free of harmful chemicals, probably shouldn't make those sorts of claims. And then finally, on the far right, we have Truly Organic. This is a retailer of bath and beauty products. They paid a $1.76 million settlement to settle an FTC complaint alleging that statements that the company's products contain 100% organic ingredients, are certified organic, and are truly organic were actually false because their products contain some non-organic ingredients. So this is clearly on the higher end of that sliding scale of risk because these claims were actually found to be false and unsupported. So with that, I will now turn it over to John to talk a bit more about carbon offsets.
Thanks, Reese. So Reese gave a quick overview already of the Delta case. That's still working its way through the courts. It has survived partial motion to dismiss, but fundamentally, this was a class action suit brought in California. Not surprising. That's where a lot of these are taking place, and the allegations were a reasonable consumer would not understand that these carbon offsets, the use of voluntary carbon offsets, doesn't actually lead to any decrease in operational emissions. They're essentially, this is kind of a carbon accounting thing. So you're still flying on a plane that is using conventional jet fuel, emitting greenhouse gas emissions. They might be going out to the market and buying credits for somebody who's like not cutting down a rainforest or what have you. And a reasonable consumer would not necessarily understand that, even with some of those little footnotes on the napkins and in other places that tell you where you can learn more. So we'll see where this ends up, but just to show you, even having that caveated language on a website that a consumer is pointed to does not necessarily mean that you're fully in the clear if you're making a claim that a reasonable person is likely to misinterpret. And I think that fundamentally raises the issue of carbon offsets. For hard to emit sectors, of which many of the folks who are listening probably work at companies that have very hard to reduce their emissions footprint fundamentally because of who and what they do, the use of offsets seems very tempting. You want to make these net zero ambitions claims. You want to be able to tell your stakeholders, your shareholders, your employees that you are a carbon neutral, or part of your operations are carbon neutral. And so the only way to do that, because you're not going to fundamentally disrupt what you do as a business. Say you are an E&P company, that's what you do. And so it's kind of hard to do that through operational changes. Maybe some industries you can actually change some things here and there, but fundamentally for some companies you can't. So you are purchasing the carbon offsets, which have come under a lot of scrutiny because the perception is that they may or may not actually be real. There's a lot of questions about the veracity of some of these projects, and was this rainforest that we're protecting really going to get cut down? And even if we are protecting it, what if it burns down? It might not be permanent. And certainly some of these things might have happened anyway. Maybe the loggers were never going to cut down this part of the rainforest because there's no roads there. And so now you're getting credit for something that was going to happen anyway. And so there's real questions around the additionality of this. And so that's led to a lot of scrutiny. And so for companies to be purchasing these voluntary carbon offsets on the open market, which I think is a laudable goal, it's coming under a lot more scrutiny than I would say in the last few years, when people thought, well, we're using the most reputable group that is compiling these credits, and they're using like the most sophisticated accounting. All of that may be true, but to a reasonable person, a consumer, they might not understand that, and they may think that they are flying kind of guilt-free. They're flying on a green airplane, and that may not be the case, and that's something that I think is a real risk to companies. Going to the point that Reese was making about future washing, again, that may be a term you haven't heard. I think you're going to probably start hearing more of it. Within like the last few months, particularly in the European Union, they're focusing in on some of the aspirational, forward-looking claims, and that I think in the United States we haven't seen much scrutiny of to date. A lot of companies, particularly in response to some of the pressures from investors that I talked about in the beginning of this presentation, went out and set net zero commitments. We'll get to net zero by 2050. We will do all of these things. Maybe they meant it. Maybe they had a rough plan to do it. Maybe they didn't. But they also kind of knew that was going to be somebody else's problem to deal with in the future. And so an oil major in Europe was just hit or found by a Paris court to be using these types of claims in a way that are misleading to consumers. So they may say that they will be net zero by 2050. The implication to a reasonable consumer is that is in alignment with the Paris Agreement. It uses the same date. However, that oil major is continuing their E&P activities, which is fundamental to their business. So to a consumer, they might be filling up and paying a premium on their gas tank, assuming that they are helping the environment, or they're furthering the cause towards achievement of net zero in alignment with the Paris Agreement goals, where the reality is the capex of the company was directly at odds with some of the things that a reasonable consumer would understand those claims to mean. So that's just something to be very mindful of. So just being mindful of time, I just want to be pointing out to folks that these types of commitments, forward-looking commitments, while we don't know where this is going to end up domestically, I think it's probably realistic to assume that what happens in the European Union is certainly going to start showing up in blue states domestically within a couple of years. And if there were to be a change in administrations, I mean, we saw that the SEC had a proposed climate disclosure rule that is likely to be wiped out, and I'd be happy to talk offline with anybody about this latest status there. Those things could come back into effect, and so just be mindful that some of these claims that were probably seen as no regrets, low risk, to the point of that Jason made, it can't be bad to try to do good. So let's make these claims anyway, and we'll just figure it out. Those give rise to real risks, particularly if those statements, claims are going to be misinterpreted by consumers, and you never really had a plausible path to getting there. I'm not suggesting that you have to publish everything that you're going to do to get to net zero by X date, but if all that you've done as a company is thrown out that we're going to get there, and you frankly never even have had a meeting internally or never had any documentation that said, like, these are the things that we're going to do, we're going to invest in this project, we're going to maybe decrease our investments in this type of project over time, et cetera. Those are real risks to companies that I think folks are now waking up to the fact that the litigation landscape has changed significantly. The last thing I would just say is, companies are caught between a rock and a hard place here. There are very real reasons to have made these claims and to want to continue to state these claims, but the risk landscape has changed significantly. I think there was a lot of herd mentality that kind of led towards people making these types of statements in the last few years. That has probably diminished, and frankly, some people are running from them, and people don't want to be left standing, and so there's some of that dynamic as well. But I think it's really important to make sure that you have the proper governance processes in place, and that's where I think most of the folks listening in are lawyers or in-house lawyers. There's a role at the table for all of you to make sure that you're monitoring what your IR teams are saying, to be monitoring what your marketing teams are saying, to put in place processes that, if we are going to say this type of claim, you don't need to have every claim run through the legal desk, but you maybe need to have kind of a general understanding of the types of claims that we're making. If you want to make this type of claim, you better run that by legal. You better run that by the CFO's office. We better have a conversation, and maybe we escalate it up to the board. Those are real things that I think should be happening. And so companies just need to be mindful that there needs to be more process around this than historically there has been. The last thing I'll just say is it's very likely that you may be tasked with undoing some of the claims and commitments that you've made as a company. I think 2025 was a check-in date for a lot of companies, and so there was already a number of companies that were stepping back from their commitments. The antitrust landscape has changed significantly, and now it feels like perhaps it's more risky than it used to be to continue to be doing these things, and we're not going to be participating in some of the industry, the cross-industry groups that maybe we once were involved in. That may lead to feeling the need to walk back from the commitment, whether that's a net zero commitment, a zero plastics commitment, a commitment to your communities, et cetera. The thing that I would just say is credibility is really important, and not to say that you shouldn't step back, but you need to be very thoughtful about how you step back. Don't just immediately cut and run. Make sure that there's the right level of engagement with your stakeholders. You are being as transparent as you can be, but know that this is a fraught landscape, and there's really no right way to do it, and you should be very mindful that there are legal risks, and that's where I think the legal organization needs to be involved. Let me stop there.
Thanks, John. And just to be mindful of time, to wrap up some key takeaways here. So first, ESG, sustainability initiatives, industry collaborations, they really do pull in a bunch of areas of enforcement risk. So keeping in mind not just antitrust, consumer protection, also securities and other areas as well for compliance. Second, as we talked about a bit throughout today's presentation, there are not just financial risks here. There are operational risks. There are reputational risks, which is arguably one of the most important risks here. And then just some proactive takeaway and next steps here for in-house counsel. Being proactive about compliance and issue spotting is really key from an antitrust perspective, making sure to evaluate the aspects of any proposed competitor collaborations, industry initiatives, making sure that legal, whether it's internally or externally, has reviewed and blessed these involvements with these types of initiatives and collaborations. Then from a consumer protections perspective, it's helpful to maintain any substantiation, as John mentioned, for any green claims that you make. In the event that a regulator, an enforcer comes knocking at your door, you can easily whip out to them and say, here's why we can make the claims that we can. And then finally, another proactive measure might include setting up a green claims committee in your organization that organizes various business units and makes sure that all messaging throughout the company is consistent for green campaigns. And then finally, monitoring key developments is really the key aspect here. This is a constantly changing environment and regulation landscape. So whether internally or calling up outside counsel to externally monitor, staying on top of key developments in this space will help you manage risk and spot issues. So with that, thank you all very much. I think we're right up on time, so we appreciate you being here today. And again, we're always available to reach out. If anyone has any questions, please do feel free to follow up with us all. Thank you.
Thanks so much.